Yes, anything? Any mentioning?
Your Lordship, I beg to mention item number 22.
Yeah, for?
I'm for the petitioner, Your Lordship. Your Lordship, I pray for...
We are for the respondents.
I pray for 1 week's time only, Your Lordship.
On prayer made by the petitioner, this is matter up to 1 week.
Highly obliged.
May it please your Lordship. Your Lordship, I beg to mention item number 19. I am for the appellant in this case. And what is there in Lordship? The conviction has been done only on the sole basis of 164 statement. So we are looking for some authority where there is a contradictory judgment of the Honorable High Court as well as Supreme Court. So to distinguish that, we are looking for some authorities. So I humbly pray for 1 week time, Your Lordship.
You take 2 weeks.
1 week will be sufficient, Your Lordship.
Up to you.
1 week, Your Lordship.
On prayer made by the appellant, this is matter after 1 week.
Highly obliged.
May it please, Lordship. Lordship, I beg to mention item number 4, Lordship. Kindly have this matter after 2 weeks, Lordship. My learned senior is indisposed, Lordship, and he's out of station for some medical checkup, Lordship. So I humbly pray for 2 weeks, Lordship.
Who's for the respondent?
Respondent, sir, did not. I don't see him, Lordship.
You're not here. On prayer made by the petitioner, this is matter up to 1 week.
2 weeks, Lordship.
2 weeks.
Obliged, Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 15, Lordship. Lordship, I pray that this matter may come up after 2 weeks.
Objection, Your Lordship.
You're for?
I'm for the respondent number 6, Lordship.
I'm for the petitioner, Your Lordship.
On prayer made by the respondent number 6, not objected to by the petitioner, list this matter after
Similar prayer for item number 13, Your Lordship. Because
2 weeks. 1 week or 2?
2 weeks, Your
2
Lordship.
weeks.
Lordship, similar prayer for item number 13 because they all are connected matter.
On prayer made by the petitioner, list this matter after 2 weeks. Yeah.
Much obliged.
May it please Your Lordship, I'd like to beg item number 16. May this matter come up after 3 weeks.
You're for?
For the petitioner, Your Lordship.
Who's for the respondent?
We have got the consents of the respondent counsel, HR Nuts, Your Lordship.
On prayer made by the petitioner, list this matter after 2 weeks.
Right.
Your Lordship, in item number 17, in fact, there was a proposed settlement.
Yes, yes.
But since the village is in a remote area, it's in Jerngam, so we have not received instruction. It was very difficult to get any instructions from them also. And a title suit which is pending before the District Council Court also now, since after the creation of Nongstoin District Council Court, it's been transferred there. So notice has been issued to them to appear before the trial court too, though there is a status quo order from this court. Your Lordship, if we jointly pray, if the matter come after 2 weeks, we'll take necessary steps.
Since the parties are trying to settle the matter outside the court, let the party appear before the trial court. If any settlement, I think that will be proper because it is in the Nongstoin.
Oh, you see, it's not a question of appearing here or appearing there.
Yes.
First, the parties have to decide.
Agree.
First, they have to agree, yes. Once they agree and decide to settle the matter,
Yes.
then, you see,
can apprise the court.
more often than not, they would, pend it. If they pen it down and bring it in the form of an affidavit or
Or a
agreement
compromise.
or whatever, then
yes,
you can file it before this court or any other court.
Any other court.
That's true, my lord. And
But
even
still, as far as this matter is concerned, notice has to be given to this court.
yes, trial court is also waiting whether the parties are willing to settle. As in the trial court also in same position.
Anyway, on learned counsel for the parties have submitted that there is still the effort for forging of a settlement or compromise in this matter is still on, for which some time is required. As prayed for, this is matter after 3 weeks.
Obliged, Lordship.
Please, Your Lordship. Lordship, this item number 14, my lord, this is connected with item number 13 and 15, my lord. So, my lord, this matter also kindly come
Then
up.
number
13, 14 and 15 Lordship.
All are
Because
connected.
15 has already been adjourned by
Your
the...
Lordship, 13 and 15 has already been adjourned. 14 is also connected with these two matters, the SSA matters, Your Lordship.
This is regarding that Hindi teacher, my
Hindi
lord.
teachers Lordship.
on pre-made by parties, this is matter after 2 weeks. Was it 2 weeks?
Yes,
2 weeks
2
only?
weeks, Your Lordship.
Fine, 2 weeks.
13 to 15.
Come on, this on the same day also.
my lord, the item number 6, my lord, we are required to file the written argument in this matter, my lord.
6,
Item number 6, my lord,
you are for
for the petitioner, my lord. So I'm
Oh,
praying
that,
for 1 week,
notification matter
my lord. Another 1 week.
on pre-made by the petitioner, this is matter after 1 week.
Obliged, Lordship.
Lordship, I'm here to make a mention for item number 20. As the arguing counsel, which is my senior, is currently unwell and unable to argue with the matter, we kindly pray for time.
On pre-made by the petitioner, this is matter after 3 weeks.
Lordship.
My lord, item number 18. Here, as per the last order, state was directed to get some instruction and file affidavit. So far, we haven't received the instruction. I pray for 1 week time.
It's
a review
It's a
petition.
review matter. So
Yes.
what instructions?
As per the last order, state was directed, because it seems both the review petitioner as well as the respondent, they have produced 2 appointment certificates. Which one is fake, which is the genuine one, could not be deciphered. Which is why the stand of the state is required in this matter, to clarify whether which one is the...
On pre-made by dealer at GA, appearing for the state respondent. Matter is adjourned, this is after 2 weeks.
Deeply obliged.
May it please your lordship, it's a joint prayer by both the parties, my lord. Item number 11 and 12, my lord. If this matter may kindly come after 3 weeks, my lord.
Mr. Jha?
My lord, this matter pertains to that discharge on the medical ground, my lord.
Yes.
My lord,
That 2 years before the...
along with the other connected matters.
On pre-made by the parties, this is matter after 2 weeks.
Which would like-
10, 11, 12.
Yes, my lord.
Item number 1.
May it please your lordship, this is a criminal petition for quashing an FIR. Just briefly, your lordship, what happened? Started in the year 2013, September 2013. The petitioner had lodged an FIR before the Limekra police station reporting against her employer, which is a company, ACME Services, a company which deals in, it's a kind of a jet fund company, where on the investment made by an investor, they give a high rate of interest. So she was an employee in this company. This company functioned for quite some time, for almost 2 to 3 years. In the year 2013, it all went down. This company had some financial problem. She was the first person on the 14/9/2013. She had lodged an FIR before the Limekra PS, reporting against her employer. The case was registered. A few days after that, there were other FIRs filed by the clients, the investors and all. These are all 13 FIRs after this, altogether 14 FIR were filed, were registered, were all clubbed in together, and investigation were carried out together. All the evidence, most of the documents which are seized from the offices and also from the main person who is the director of this company, documents were seized for them. In the FIR, most importantly, Your Honor, in these 14 FIR, not even one mention is made of the petitioner. All the allegations were against the company directly and against the director. The documents which are seized, all of it were, none of it are mentioned, the name of the petitioner were not there. Including in the charge sheet itself, she was made a complainant and a witness. Yet she was made, at the time of filing a charge sheet, a charge was also framed against her. She was made an accused in this case, which is very shocking. So for that reason, I have relied on two authority. That is in the state of Haryana versus Vajanlal, which was with regard to on the face value, if there is primacy, no offence is made out against accused person, exercise can be made under for quashing the FIR. So briefly, that is what I want to submit.
I'm appearing for the state, my lord.
What is your submission here?
My lord, if my lord will go through the record, my lord will find this case, my lord, involves a major fraud, my lord. Now, an amount of rupees 6 crore plus, my lord, has been duped from the innocent clients, my lord, from Meghalaya, who are, some of them are daily wage laborers who have deposited some of the money in with the institutions. Now, as far as these sort of cases are concerned, my lord, where it involves a major fraud, my lord, the power under section 482, my lord, it cannot be exercised, and there are various judgment because this relates to economic offences, my lord. So I'm appearing for the state, my lord.
What is the stage of the case?
It's still fixed. Now it's been 9 years. It's still fixed for argument before judge. Reason being that it could not proceed is because there are a lot of other accused persons. Their attendance could not be secured. That was the reason. Since this was charged sheet in 2015.
But that should not stall the proceeding.
Right, exactly.
It can be segregated.
See, there are procedure
that is what
already available in the court.
Yes.
See, CRPC is very clear on it.
Exactly.
You can proceed against the whoever is there, and then the rest can be the proceeding can be kept in abeyance as far as. But 9 years.
Since 2015, we do a charge sheet. It took around 2 years to charge sheet. And also, most importantly, as per the charge sheet, the IO has stated that the ground that he has recorded the statement of all the witness, of the witnesses and all. But I've checked the record. Not even one statement is there of any of the witness. There are around 65 witnesses he had submitted. Not even one statement he has submitted with the charge sheet. Simply a charge sheet has submitted, and that's it. All the allegations against the company. In the charge sheet itself, the petitioner here is referred to as a complainant and witness.
My lord,
as far as what my friend has said, that it's economic, we understand that. But the offence under which it's a cheating case against the company, and nothing as such relating to the economy or something like that has been mentioned in the
whatever. You have to read the whole matter in a wholesome manner.
All the other affairs, well, 13 affairs, they were clubbed together. They are part and parcel of the previous affair.
And none of which, not even one allegation, not even a name mention of the petitioner. Not even one. Just directly in the name of the director and the company. That's
record shows that she is the one who has collected a huge amount of money from the people.
She's an employee. She's working on the behest of the employer. Whatever has been assigned to her, her duty, the duty of the petitioner was to motivate the unit manager. She was not at all involved directly with anyone. The evidence which is collected, the bank account, whatever has been collected of all of the company, the investor deposit directly in the company, none of which had come through her. I have also made here the pleading here. I've mentioned it here. None of the account. It's mentioned clearly.
Mr. Marpan, I don't think this submission is not required to be made at this stage. Since the forum is there for you. You have to, let's put it this way, clear your name before the appropriate forum.
Exactly.
Coming before this court, like I said, in the other day, this court has remarked on petition of this kind, and you cannot short circuit a process.
Exactly.
In fact, involving a magnitude of this kind, I think it would not be proper for this court to take cognizance of it. You may be an accused, you may be a complainant, whatever the case may be. The recourse is available at the before the competent court.
Exactly.
You take your chances there. The court cannot do away with the whole proceeding at this point of time, because it has not only affected you, affected others also.
Yes.
Now, as I used to say, it's up to you whether you withdraw the petition or I dismiss it.
But Your Lordship, prima facie, it's very clear. You can be seen on the FIR and the everything. None of it.
That is not for this court.
If Your Lordship could
This court cannot go into the details of the evidence. It's only, 482, you have quoted Majanlal case. Read through all the whatever is there in Majanlal. Paragraph 103, what does it say? Only in rarer of
ingredients of
rare case that you can take up.
I feel the portion that I said regarding the exhaustive list, that it fits under that 1, 2, and regarding the prima facie on the face of it, the FIR itself, nothing as such.
That is so. That is why you prove it. You see, you prove it before the competent court.
Yes.
I think it's fixed for argument before charge. Yes. So there you can be discharged if there's nothing against you.
Yes, we've been trying because now it's been 9 years, so that's why we had no other.
It can always be segregated, my lord. The people who are absconding and those who are present.
Because it's up to you. If you want me to dismiss it, I'll dismiss it on merit or otherwise.
All right, right.
And Mr. Sincon?
Yes, ma'am.
It will do good for you as a prosecution to ensure that the proceeding is speed up.
My lord.
You do it at a personal level, or Mr. Marpan can come with a separate petition only on the ground that the proceeding has been delayed.
Right.
That cannot be.
That is true, my lord.
The counsel for the petitioner has submitted that this petition may be withdrawn. On the submission so made, the petition is accordingly dismissed as withdrawn.
All right.
From daily cost list, item number 1.
Yes, who's appearing here? Who is respondent for?
Sorry, Your Lordship. Actually, I have no instruction to appear, but I'm the local counsel in this case, Your Lordship. So we have already filed the affidavit to bring into records the status report.
You are in this case?
Your Lordship, I have signed the Vakalatnama.
Then
They
why
were
do you say
supposed-
you have no instruction?
You want to know?
What is this case of ordinance?
Also, this is another case of economical offence. Here, what has happened? The petitioner, in connivance with her husband and some other person, they have floated one fake website, thereby promising admissions abroad as well as in the country. Thereby, they have siphoned lots of huge amount of money. And here, particularly the present petitioner here,
excuse me,
her extent of involvement is that the kingpin of the entire episode is her husband, and they were staying jointly. Meghalaya police has raided their house at Patna and recovered a room full of documents, false certificates and all. And in this whole transactions, the petitioner's bank account was being used for lots of money, transaction of money. So therefore, Lordship, they have come under 482. This is a case, there is nothing that shocks the conscience of your Lordship to see that the allegation made is not bona fide or prima facie. Therefore, Lordship, there again the Lordship, this Bhajanlal case will be attracted there. So under the guidelines of that, Lordship, it is not maintainable at all, Lordship. And there are other co-accused to be apprehended, Lordship. And it involves entire states, Lordship, entire states of the country.
Your Lordship, I pray that if this matter may come out after 1 week, Your Lordship.
I don't know.
Then counsel for the petitioner has submitted that the notice issued upon the respondent 4 has been duly affected, and you filed your affidavit of service.
I have already filed, Your Lordship.
I haven't received.
I've already given a copy.
For which an affidavit of service has been filed in this regard. It is prayed that this matter may be heard on the next date fix.
Deeply obliged.
As prayed for, this is matter to 1 week.
Highly obliged.
Item number 3.
May I please, Your Lordship?
Yes.
This case, Your Lordship, as per the status report, Your Lordship, with regard to private respondent number 3 and 7 have duly served, Your Lordship. The remaining left with 4, 5 and 6 which return unserved.
Oh.
Actually, Your
So
Lordship,
have you taken fresh steps?
Because
Then you too should take fresh steps.
as per the report, Your Lordship, which we gathered, status report, Your Lordship, the addressee cannot be located with those 3 private respondent, Your Lordship, because the address is we sorted out from the chart sheet itself, Your Lordship.
Then you have to
In
make
fact,
an
Your Lordship,
make an
this-
effort, try to find out their correct address.
In fact, this matter, Your Lordship, is between the petitioners, both petitioner
Oh,
one.
this is with regard to this to village.
Yes, to village, Your Lordship.
Okay.
And
And
nothing with the private
but even
respondent.
then you see, they are the victim, isn't it?
That's true, Your Lordship.
They were the one who were assaulted.
Minor injury, Your Lordship.
Whatever. Yes, perhaps they may have, gone
Yes,
back
yes,
to
I
their
understand.
own place. It's difficult, no doubt. But then, what can we do? You have rated them as respondent.
Let them take fresh steps, Lordship, for
You
5.
find a way.
After a week, Your Lordship, in the meantime, I'll take necessary step, Your
Yeah,
Lordship.
you try to find
Yes.
a way.
Find
Yes.
the correct address also.
Perhaps you may have a case here, but then you see.
Within a week or after a week, Your Lordship, the matter will be listed. In the meantime, will take necessary steps.
And this is the dispute between those two villages, Lordship. And the headman also, it's not a party here.
It's there, Your Lordship. He's a petitioner number one.
Headman of the two
complainant.
villages. Headman of the two villages. One is, of course, one is he's there. He's a party, but the headman of other village.
Essentially, a dispute between two villages.
Two villages.
Which they have already settled, Your Lordship.
You have anything on record? Any settlement?
Yes,
deed
Your
of
Lordship.
settlement?
Everything is there, Your Lordship. In fact, they have it's a land dispute.
You have not read him the headman of the other village as
If
a
I'm not
party?
mistaken, Lordship, this petitioner number one also, he's the ex-headman, not the present headman.
He's a complainant, Your Lordship.
Complainant.
As a headman.
He was the complainant, but at present he's the ex-headman.
What about the respondent?
They are all the accused, Your Lordship. Petitioners number 2, they are all the accused. Petitioners number 10, Your Lordship, he's a headman.
Petitioner number 10?
Number 10, Your Lordship.
How many petitioners are there?
Altogether 18, Your Lordship. Petitioners number 1 is the complainant and the rest is the
petitioner
alleged as accused person.
Okay, this petitioner number 10 is the headman of the other village.
Other village, Your Lordship.
And you are the petitioner number 1.
I'm filing on behalf of petitioners 1 and 2, Your Lordship. Joint petition. Since the matter already been settled, which is a land dispute between the two villages.
Petitioner number 1, Lordship, he is the complainant and also the ex-headman of that one village. And petitioner number 2 to 18, they are the residents of that other village, as per this cause title that they have given here.
These respondent 3, 4, 5, 6 and 7, they are laborers.
They are laborers, Your Lordship. From 3 to 7, they are laborers. They have already fled the scene right from that incident, which that point of time, Your Lordship. Even in their own statement, victim statement, Your Lordship, they have already clearly mentioned that it is because of the land dispute between the two villages, Your Lordship.
What is the stage of the proceedings before the trial court?
This is presently fixed for explanation of substance, Your Lordship.
Summary proceedings.
Summary, please.
Consideration of charge, I think.
In fact, this matter has been referred to the session court also, Your Lordship, because some of the two offence has been...
So it must have been committed to the sessions court.
Yes, and has been omitted. In fact, the observation also have been made, Your Lordship, by the sessions court that since the matter has already been settled, if I may read, Your Lordship. However, if such settlement deed will
You're
show...
reading what?
The trial court, the sessions court order.
Yes, where in your petition?
Page 22, Your Lordship.
Please refer to relevant. Yes. What does it say?
I may read the last para, Your Lordship, of page 22. Defense submitted that actually this case is the outcome of a civil dispute over the land and that the settlement between both sides has been drawn formally on the settlement deed dated so and so, registered with sub-registrar Clariat, which had been submitted on record by a joint application of both sides to the committal court on 15/12/2021, and the same is found on record. However, if such settlement deed will show the civil dispute as the genesis of this criminal case, yet closing the proceeding of the case at this stage by this court is not arisen, as it will amount to quashing of the FIR, which is beyond the power of this court. Besides, after perusal of material on record, since some ingredient is available for the criminal offence of causing hurt to the victim as per the injury report, but the injury report of the victim is the only material available on record, which is showing minor injuries. Hence, this court is agreed with the parties that the charge under section 337 IPC is well attracted to this case in place of the charge sheeted under section 325 IPC, and the charge stood altered accordingly. This court also agreed with them that this case is lacking material to proceed trial for the charges under section 120B, 427, 436 IPC, and the same are dropped. Since the applying altered charge under section 337 IPC triable by any magistrate, hence let the case be rolled back to the committal court of the learned CGM, who may try the case by itself or endorse it to the learned GMFC for its disposal. All accused persons are to appear before court of learned on 16/12/2022. Just because the learned court, sessions court, does not have jurisdiction to quash the proceeding, otherwise
337, what does 337 says?
327. Causing hurt by act endangering life of or personal safety of others. Whoever causes hurt to any person by doing any act so rashly or negligently as to endanger human life or the personal safety of others shall be punished with imprisonment of either description of a term which may extend to 6 months, or with fine which may extend to 500 rupees, or with both.
See, this is compoundable.
Compoundable.
It can be,
yeah.
see, it can be compounded at the stage of the
But
the
by
trial court.
compoundable by whom hurt has caused, Your Lordship. But
Exactly now. See, so what you should have pursued is pursue the matter before the trial court. Pursue the matter before the trial court. Try to get those the victims.
It'll be on the same stage as Your Lordship.
Exactly. But now, see, in that case, if there's already an alternative remedy, I think this court cannot take up the matter at 42.
And also, Lordship, this is the dispute on the issue of boundary, Lordship.
Whatever the
On
case may be,
issue of
we are not here on the. You see, that apart, when the court has, the learned sessions judge has clearly opined that it is, the matter is triable only by a magistrate. In as much as all the relevant sessions tribal sections have been done away with. So now only 337 remain, which you could have easily gone before the magistrate and get it compounded. Why come before this court?
The big issue is this, Your Lordship, because the victims here is
exactly. Now, before this court or before the other court, you still have to get those victims. You still have to get them. In fact, the process would have been much better for you before the trial court, because the other provision of CRPC can be resorted to in case they could not be found. Whatever the case, some time would be given, and then the matter would be closed. Why should you come before this court? I think you have no case. Best option for you is to you withdraw this matter and pursue the same before the. Otherwise, what will happen is you will keep on, waiting for the summons for the service report, which will never come. It may come, may not come. So unnecessarily, matter will just drag. You take a chance.
And also, it will never end, this Lordship. This kind of matter will never end.
Therefore,
dispute, if it's not settled, that boundary dispute, if it's not settled, again, this kind of
that is
incidents will happen.
That is a different issue. We are talking about only what is relevant here.
Yes.
I think that is, it's up to you.
I'll please withdraw, Your Lordship. Proceed with the.
Yeah, you proceed before the magistrate. Learned counsel for the petitioner has submitted that he may be allowed to withdraw this case. On submission so made, petition is dismissed as withdrawn.
Just humble prayer, Your Lordship, if this matter is long pending, if some expeditious direction to dispose of it. Since
Once it is-
2009.
2009?
Yes, Your Lordship. Some direction, Your Lordship.
However, before parting, the learned counsel has submitted that the trial court may be requested to proceed with the case expeditiously, since the matter is a long pending one. Accordingly, the learned trial court, who has taken cognizance of the case of the party, is requested to expedite the process in disposal of the said case, while disposing the said case.
Highly obliged.
Item number 5.
Yes. I think Mr. Sangrisu was not here.
4 and 5 the similar matter.
4 and 5 same order.
Item number 7.
Yes, Dr. Sir.
My Lord, this petition, my Lord, criminal petition number 23 of 2018, my Lord.
Yes, tell me.
My Lord, it has been filed for passing of the criminal complaint.
You come under 482?
482, my Lord. And as well as, my Lord, the proceedings initiated by the Judicial Magistrate Shillong under section 134(8) of the Companies Act. My Lord, I have also given one compilation, if your Lordship has got it, my Lord, compilation.
Perhaps this is the one. Yes.
My Lord. My Lord, a complaint was made under section 134(3) of the Companies Act.
Mr. Devnath, you ready?
Your Lordship,
Because you see, halfway through the hearing, I don't want to hear anything from you saying that I'm not ready, not prepared, this and that. So, before we start, be sure. Dr. Saraf is already ready.
Yes, Your Lordship, I have to prepare so many is there.
I know that. It's a
No, on the last occasion, Your Lordship made it clear that Your Lordship will take.
It's a very old matter, Mr.
I'll give the reply in another day. And I have to prepare some bullet points. So many matters.
My Lord, for last 1 year, he is preparing how much, my Lord, it will become very difficult. My Lordship may see, my Lord, there is no case. I will show to Your Lordship, my Lord, Lordship may kindly see, my Lord.
Yes, that is true. But you see, we have also to at least give the proper opportunity to all concerned.
Well, I understand, but my Lord, for the last 10 times, my Lord, the times is being taken by the respondents. And
What
on
you
the last occasion,
Dr. Saraf, what you can do, Mr. Devnath has, fairly conceded He is not prepared today, but if you want to start your case, you start and let him reply on the next date.
As your lordship, as per it's absolutely up to your discretion of your lordship, but I will not.
Yes, I think let him start. You take down his note of arguments and then you can reply on the next date. But you have to be prepared. In fact, this matter has been going on for so long. Please continue.
My lord, my lord. My lord, this complaint has been made under section 134(3) of the Companies Act, my lord.
Yes.
And the cognizance has been taken and summons have been issued.
Yes.
Now, my lord, I have taken your lordship to the legal arguments, my lord, first. First argument, if your lordship may see in my compilation I made, my lord, that the judicial mistake, Shillong had no jurisdiction to entertain complaint under section 134(8) of the Companies Act and for alleged violation of section 134(3) of the Act, page 1, my lord.
Yes.
Bottom, my lord.
You are
My compilation.
referring to what page?
My compilation, page number 1.
Number 1. Fine. Yes. Please.
Well, section 435 of the Companies Act, my lord, provided for establishment of the special courts, which you'll also find I quoted it at page 2, my lord.
Yes.
Now, this establishment of the companies, my lord, the special courts, you'll also find, I may read, my lord. The central government may, for the purpose of providing speedy trial of the offences punishable under this Act, with imprisonment of 2 years or more, by notification establish or designate as many special courts as necessary, provided that all other offences shall be tried, as the case may be, by the Metropolitan Magistrate or Judicial Magistrate, or first class having jurisdiction to try such offences under this Act under any of the previous company law. A special court shall consist of a single judge who shall be accompanied by the central government with the concurrence of the Chief Justice of the High Court, within whose jurisdiction the judge to be appointed working. A person shall not be qualified for appointment so. So, my lord, where the offence is for more than 2 years, then it is to be tried by the special court. Now, you will also see the next page, my lord. This is section 436, my lord. Yes. Offences triable by the special court. These are the offences, my lord, which are to be triable by the special court. Now, the offence which 134(3), my lord, is for offence is for my lord, the imprisonment for 2 years imprisonment, lord. The offence for 2 years imprisonment, and so it will be fall under the special court. Now, a notification was issued, which you will also find at page 4, my lord. At the bottom, my lord.
Yes.
The Government of India Ministry of Corporate Affairs, by notification dated 17/11/2016, designated the Court of District and Session Judge Shillong as the special court in exercise of the powers conferred under subsection 1 of section 435 of the Companies Act for the purpose of providing speedy trial of the offences punishable with imprisonment of 2 years or more under the Companies Act. The jurisdiction of the special court is specified in the entire state of Meghalaya. Now, Annexure 1, I annex the notification of the Ministry of the Company Affairs and this one. So, the proceedings,
yes,
in respect of an offence under section 134(3), where the offence is for more than 2 years, is to be special tribal by the special court, which has been already been established by way of a notification. Now, we'll also see the next page, page 5, at the top, my lord.
Yes.
Section 438 here, my lord, see. Application of the court to proceedings before the special court, save as otherwise provided in this Act, the provisions of the Code of Criminal Procedure shall apply to the proceedings before a special court, and for the purpose of said provision, the special court shall be deemed to be a court of sessions and court of metropolitan magistrate or judicial magistrate first class, as the case may be, and the person conducting the proceeding before a special court shall be deemed to be a public prosecutor. Now, 440 of the Companies Act contains a transitional provision. The said provision provides that any offence committed under this Act, which is triable by the special court, shall, until the special court is established, be tried by the Court of Sessions, exercise jurisdiction in an area, notwithstanding anything contained in the Code of Criminal Procedure, provided that nothing contained in this said section shall affect the powers of the High Court under Section 401 to transfer any case or class of cases taken cognizance by the Court of Session under this section. So before the Milord, the special court was established, the same was to be triable by the Milord, the court, the Sessions Court. But after the special court is established, Milord, this has to be, Milord, exercised, the power is to be exercised by the special court only. Now, once the Milord, the special court has been established by way of a notification by the Ministry of Corporate Affairs, the judicial magistrate, Milord, has no power and jurisdiction to take cognizance of the offence under Section 134(3) of the Companies Act 19so. So entire initiation of the taking cognizance of the offence by the judicial magistrate is actually legal and without jurisdiction. This is my first contention before your Lordship, Milord. Now, the second, Milord, argument before your Lordship is that, Milord, that at page 6, your Lordship may see the heading, Milord, the ground which I have given.
Yes.
The issuance of the summons to the managing director and the directors of the company is illegal, and the company and the contrary to the provisions section 134(8) of the Companies Act. Now, Milord, 134(8), if your Lordship looks into, Milord, the Companies Act. Yes.
Yes, 134.
8, Milord, 8.
8.
My Lord.
Yes.
Well, if a company contravenes the provisions of this section, my Lord,
yeah, please.
The company shall be punishable with a fine which shall not be less than 50,000 rupees, but which may extend to 25 lakhs rupees, and every officer of the company, your Lordship may kindly notice, my Lord.
Yes.
And every officer of the company who is in default shall be punishable with imprisonment for a term which may extend 3 years or so and so. Now, here the term which has been used is, my Lord, the officers of the company. Now, wherever the legislature wanted the director or managing director, well, it has been specifically mentioned, you Lordship may kindly see section 129(7), my Lord.
Seven. Yes.
My Lord. If a company contravenes the provisions of this section, the managing director, the whole-time director in charge of the finance, the chief financial officer, or any other person charged with the board with the duty of complying with the requirement of the section, and in the absence of any of the officers mentioned above, all the directors shall be punishable with imprisonment for a term which may extend to so and so, so and so. So wherever the legislature wanted, my Lord, the managing director or the directors or chief executive officer to be, my Lord, made liable for the offence, my Lord, they have specifically incorporated in the provision itself. If your Lordship compares the provision section 134(8) and 139(7), your Lordship find that in the same act itself, 134(8) only speaks of the officers, and 124(9) speaks of the managing director, the whole-time director, and all of the directors.
So there's a distinction made between the executive and the ministerial rank.
Officers, my Lord. So 134 only speaks of the ministerial officers, my Lord, and 129 only speaks of the managing director, directors, and all those things. Yes. So since, my Lord, as you Lordship is aware, my Lord, when there's in the same statute, one provision speaks of, my Lord, a particular provision of the particular thing, and another one omits it, then it is to be presumed that those persons are not included. So, in my humble submission, my Lord, 134(8) nowhere provides for that the managing director, or other persons, my Lord, other than the ministerial staff, will be liable for any offence.
Okay.
So, my Lord, since 134(8 doesn't speak of the managing director, directors, etc. The issuance taking cognizance of the offence against the managing director, other directors of the company, in my humble submission, is illegal and contrary to section 134(8 of the Act. Now, my lord, page number 7, my lord.
Yes.
You also may see no pleading in the complaint that the managing director and the directors were in charge and responsible for the business of the company. Now, as your lordship is aware, my lord, the number of decisions of the apex court, which I have also referred, that unless and until in the complaint it is mentioned, my lord, that those persons, managing director or a particular person who are responsible for the business of the company, all the directors or managing director cannot be made, my lord, liable for the offence. My lord, I have referred to all the judgments. You will also may see at page 8.
Yes.
The two decisions, my lord, I have annexed the decisions also, my lord. PepsiCo India and SMS India, my lord, so and so. And you will also may see the observations in the center, my lord, in the italics. It is by now established that a complaint against a company and its directors, the complainant had to indicate in the complaint itself as to whether the director concerned were whether in charge or responsible to the company for the day-to-day management, or whether they were responsible for the company for the conduct of the business. A mere bold statement that a person was a director of the company against which certain allegations have been made is not sufficient to make any director liable in the absence of any special allegation against his role in the management of the company. Now here,
I think Dr. Sharaf, this comment was made in the background of a, if I'm not mistaken, of a 138 NI Act proceedings.
My lord, there is no doubt about it. But my lord, you will also see the law 134(8 also, 134(3 also, if your lordship reads, well, all the directors and the managing director, if your lordship looks into, my lord, 134, 1 second, my lord. You will also see, my lord.
Yes.
134. If the company contravenes the provisions of this section, the company shall be punishable with fine which shall not be less than 50,000 rupees, but which shall extend to so and so rupees, and every officer of the company who is in default.
Yes.
So one must say, my lord, that is this particular officer, although I am saying that, my lord, here only officer is there, directors are not there, and managing directors are not there. Assuming for the argument's sake, my lord, the managing director and director is there, then also one has to prove that yes, this person is in default. Otherwise, my lord, you cannot make all the directors and managing director as a committed in the accused in a complaint. And that's why, my lord, I am referring to these judgments that, my lord, when the person is to be made liable for an offence, you have to make a special pleading that yes, this person or this director is in default. Now, there is no statement in the complaint about any director that in this director is liable or this director is in default. Now, in the absence of these statements or pleadings, my lord, in my humble submission, the judgments of the apex court will be squarely applicable in the present case also, because that were also in the same analogy that when the complaint person responsible for the affairs of the company, here the person officer who is in default. So one must say that this person is in default. If you don't say that this person is default, how will all the directors and managing directors can be made accused for an offence under section 134(8) of the Act? Now, I have also relied on, my lord, the decisions. My lord, you'll also see in the same page at the bottom, my lord, Shiv Kumar Jatia versus State of so you can say, my lord, a corporate entity is an artificial person which acts through officers, directors, managing directors, chairman, etc. Here also, you'll also make a note, my lord, the Supreme Court decision. It says through its officers, directors, managing directors. I was making a distinction, my lord, between officers, directors, and managing directors. If such a company commits an offence involving mens rea, it would normally be to the extent and action of that individual who would act on behalf of the company. At the same time, it is observed that in the cardinal principle of criminal jurisprudence that there is no vicarious liability unless the statute specifically provides for it. It is further held by this court that an individual who has perpetrated the commission of an offence on behalf of the company can be made an accused along with the company if there is sufficient evidence or active role committed by the criminal intent further so and so. So you must say, my lord, that this person is in default and he has committed the offence. Unless and until this is, my lord, pleaded in the pleadings, my lord, a person, all the directors and managing directors in a mechanical way cannot be made accused in the complaint, my lord. Now I will refer to other decisions also, my lord, that I am not referring to. It is there in the, my lord, my written submission, as well as, my lord, I have annexed all the judgments also.
Yes.
The lordship may come to page 10, my lord, the next point, my lord.
Yes, please.
Issuing of process without taking cognizance of the offence is illegal. Now, if a lawsuit looks into the order by which the summons were issued, my lord, no cognizance of the offence has been taken. It is mechanically you have said that issue summons. Now, summons, issuance of summons is not a mechanical act. Your lordship may see, my lord, I have referred to a judgment which your lordship will see in the same page bottom, my lord. The apex court in so-and-so, while examining the duty of the magistrate, while talking cognizance of the offence laid down as under, Section 200 CRPC provides the procedure for the magistrate taking cognizance of offence on a complaint. The magistrate is not bound to take cognizance of offence because a complaint has been filed before him, when in fact the complaint does not disclose a cause of action. The language of Section 200 CRPC, a magistrate taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses on presence so-and-so clearly suggests that for taking cognizance of offence on complaint, the court shall examine the complaint on oath. The object of examination of the complainant is to find out whether the complaint is justifiable or vexatious. Merely because the complainant was examined, that does not mean that the magistrate has to take cognizance of the offence. Taking cognizance of the offence means the magistrate has judicially applied his mind to the contents of the complaint and indicates that the magistrate takes judicial notice of the so-and-so. Mere presentation of the complaint and receipt of the same in the court does not mean that the magistrate has taken cognizance of the offence. Now, in this case, my lord, the learned court below, my lord, simply on the basis of, my lord, the filing of the complaint, has mechanically issued the summons. Now, summons cannot be issued, my lord, unless and until the magistrate takes cognizance of the offence. And if he takes the cognizance of the offence, he must apply in mind and pass necessary orders. Without that, my lord, how a summons can be issued to the accused persons? So, in my humble submission, that is a clear violation and non-application of mind by the London magistrate in taking issuing the summons to the accused persons. I have referred to the other judgments, my lord. I am not relying on that, my lord, for the sake of unnecessary. I am not taking this as time of your lordship, my lord. I am given in the written submission.
Yes.
I am skipping over and coming to my lord, page 13. Non-compliance of the provisions section 202 CRPC before issuing summons to the accused residing outside the jurisdiction of the court.
Excuse me.
Now, your lordship is well aware, my lord, of the various decisions of the apex court that section 202 compliance is mandatory, and if the 202 is not complied with, then summons cannot be issued to the persons accused residing outside the territorial jurisdiction of the court. Now, I will refer to the judgments. Your lordship can see, my lord. Page 14 at the bottom, my lord.
Yes.
And the relevant part at page 15, my lord. The use of the expression shall prima facie makes the inquiry, investigation as the case may be, by the magistrate mandatory. The word shall is ordinarily mandatory, but sometimes taking into account the context or intention, it can be held directly. The use of the word shall in all circumstances is not decisive. Bearing in mind the aforesaid principle, when we look at the intention of the legislature, we find that it is aimed to prevent innocent persons from harassment by the unscrupulous persons from the false complaints. Hence, in our opinion, the use of the expression shall and the background and the purpose for which the amendment has been brought, we have no doubt in mind that the inquiry or investigation, as the case may be, mandatory before summons are issued against the accused, living beyond the territorial jurisdiction of the court. Now, next judgment, my lord, 2019, my lord, when it was held that the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto, and the application of mind has to be indicated by disclosure of mind on the satisfaction. The apex court further held that considering the duties of the part of the magistrate for issuance of summons to the accused in a complaint case, that there must be sufficient indication as to the application of mind, and object that the magistrate is not to act as a post office as a combination of the offence. Now, Lordship, last part, my lord, Lordship, may see. Allegations made in the complaint does not make out any prima facie case, as the same is an abuse of the process of the court. Now, my lord, the complaint was filed against the petitioner for the following reasons. In the secretarial audit report dated 2016-17, it was commented, well, I quoted it, during the period under review, the company has complied with the provisions of the Act and rules, regulations, standards, etc. mentioned above, save and except that the company has filed advance notice for keeping registers and annual returns at the place other than the registered office of the company under Section 94 of the Act after passing the shareholders' resolution. This comment was made in the italics, but no explanation thereof was furnished in the board's report, contrary to the provisions of Section 134(3) of the Act. Now, we also see the one so-called notice was issued to me, my lord, and I have given in the so-called notice the entire reply that what was the reason for this. Now, that has not been considered at all by the my lord, by the authorities, my lord, and just complaint has been filed. Now, if you also look into my reply, I have mentioned, my lord, at second paragraph of page 16.
Yes.
In this connection, a so-called notice was issued by the company through the company, and reply so-called notice was also submitted to the company. In the same reply, it was stated that in respect of observations made in the above so-called notice, it is submitted that the secretarial audit report clearly spelled the issue in the report about filing of the advance notice for keeping the registers and annual returns at a place other than the registered office of the company under Section 94 of the Act after passing the shareholder resolution. Further, the remedial action by the company was also stated in the secretarial report in the remark itself. It was further stated in the reply that the board of directors in the report stated that the report is self-explanatory and do not call for any further comments, and director did not have any further comments or explanation to make, and therefore, for the sake of brevity, the remark and explanation given in the secretarial report was not repeated, copied in the board report, and the company had duly filed the shareholders' resolution while so and so after meeting of the shareholders. Therefore, the required information was already provided, and thereby there was no violation of Section 134 of the Act. Now, my lord, in the report it was mentioned, and they have said only because you had mentioned it only as in italics and not given any more explanation. The board of directors, my lord, said that whatever was there, that is accepted. Now, whatever was there is accepted means it is approved. So there was no cause of action also, my lord. In any case, ultimately, my lord, if all my arguments fail, then also a plain reading of the, my lord, the complaint you will also find that no offence has been made out under Section 134(8) of the Act. Now, thereafter, my lord, I have given some judgments which are not necessary, you will also be well aware, by the scope of the power under Section 482 of the Code. I am not referring to your lordship is well versed with the, my lord, the judgments of the Apex Court, that what is the scope of the power under Section 482 of the Act. Yes. So, in my humble submission, taking all the grounds, my lord, there is, my lord, absolutely, my lord, abuse of the process of the court, and there is no case has been made out for taking cognizance of any offence, and more particularly that the authority magistrate has no power and jurisdiction after the special courts have been established, and thereby, my lord, in my humble submission, the complaint as well as the proceedings are liable to be quashed.
When do you want it?
Well, this is the first. Well, this is the first one. Second matter is different, my lord.
Second matter is different.
My lord, they are all on different points.
I think, Dr. Saraf, what we can do, I think we'll have to wait for Mr. Devnath to be prepared. But the essence would be, in all the petition, essence would be the same.
Essentially, same. In some of the sections are different. In one case, the complaint has been made in a particular section, and wherein the section itself provides that no, there is no offence at all. So in that way, I filed written submission for all the cases with my written submissions along with the annexures, so that to make it easy for Lordship, that Lordship will not take the trouble of making notings and all those things.
Yes, thank you very much. Mr. Devnath, you have gone through these written submissions.
Yes, I've gone through, but I was not actually mentally prepared.
You
because
just
this
have to
last question
complete
also, just I make.
Everything is ready-made for you.
It means ready-made.
All judgments, everything is there, my lord.
1 week.
Ready 2 weeks, Your Lordship. I have to prepare. So many matters I didn't go through so properly.
At least take the trouble of looking into my matters also, so that some matters he is very busy, but if you can oblige me, my lord, by looking into my matters also.
2 weeks. No more adjournment.
Well, if your lordship can fix up a date, that will be.
Yes, you suggest a date.
Possibility. 25 people. 25/5, my lord.
25/5 perhaps may not be suitable.
24, 26, my lord, any date.
26. And let's have it on 26.
26, my lord.
26.
Miles.
What? Dr. A. Saraf, Learned Senior Counsel, appearing for the petitioner. The Learned CGC, Mr. R. Devnath, however, has sought for some time to reply to the argument advanced by the said Learned Counsel for the petitioner. On preamid, seems allowed. As prayed for, list this matter on 26 for further hearing. So 26.
Lordship, I will request, my lord, the other 3 matters also, Mr. Devnath may look into it. So the 26.
Exactly, that's what I said.
It is the same. Section CRPC 200 is not applicable in this case, because this is not the criminal complaint as such. So first, second is they are using for jurisdiction. Already as per definition is there. Then and moreover, this referring this notification, it is for 2 years and more, and it is going to the up to the 3 years. So this also not good. So I will be coming on this point.
If you are ready, then argue.
Sir, today, as because already they said tell that today will not be doing. So that's why I should not even give me trouble also, sir. When this also came to know this, today I was little bit, and I was not even in a position to attend your call yesterday.
Okay.
So I should not make trouble in this giving information to one, and after this the court should not play in another way. I should have this respect to you, sir.
Yes.
Because I was not in a position to take your call yesterday. There was some problem. And then after this in the late night, I was not even to give any communication and presume that it is going to be adjourned. So if I start now, it is not wise. You are senior counsel, sir, and I am having this respect.
The court is always there. The court is bound to take up any matter, except, the court more often than not would, accommodate the parties as and when it is feasible.
You lost it. The things is here yesterday happened from the third chamber telling to me, but I was not in a position to take calls due to some personal matters. And I was thinking whether I'll be in a position to, and then I given some information to somebody that if it is, then I may not be ready, so just inform sir. So when sir, this your lordship, I have sent some communication. So if I said that I am ready to argue another, it's not also wise.
Today there is a holiday in the Guwahati court.
We could have disposed of, and we have plenty of time today. Fine.
I'm grateful to you, Lord.
Thank you.
Item number 21.
May it please your lordship, I prefer some accommodation in this matter, my lord. My lord, if this matter may come up along with the other two matter, my lord, criminal petition number 36 of 2023 and criminal petition number 37 of 2023, which is coming up on 6th of June.
6th of June.
Well, that has got nothing to do with this, and I feel it would be too much to pressurize a senior counsel to argue 3 matters on a single day. I'm very much willing to argue it on any other day. If it doesn't work today, I am willing to argue on any other day.
So if they want to, because I was under the impression that they wanted together, my lord. So now since it has come, after 2 weeks, my lord, any day, my lord, I can argue the matter on that day.
Okay. Dr. N. Musiga, Leonard DSDI has sought some accommodation in this matter, to which the respondent has no objection.
If it can be listed somewhere around 6th, my lord, like 2nd of June or something, that would be.
Whatever. You can decide on a date if you want to.
I'm okay.
2nd of June is fine. 2nd of June. Friday. It's a Friday, my lord.
As prayed for, list this matter on 2nd June.
Yes.
By the way, what's the issue here, Mr. Dr. Musiga?
In this matter, my lord. But in this matter, some witnesses have been cross-examination kept in abeyance, my lord.
Oh.
Our case is that will prejudice the case, my lord. Other prosecution witnesses have been asked to be.
It has to be given to the court. Otherwise, if everything is scrutinized by higher courts, then where will we be? If it is, you see, if it doesn't contravene the, the principles of law or the set provisions of law. If that is the case, you think
to pursue
you think either you pursue this court or you withdraw and pursue the matter at the relevant or competent court. Thank you.
Obliged.
Yeah.